Today is 26th of November 2012. Last year, that is on 26th of November 2011, I started recording as far as the Criminal Procedure Code is concerned, and after recording 57 videos, then decided to start with the provisions of the Indian Penal Code, and already uploaded 62 videos as far as the Indian Penal Code is concerned on the YouTube. Taking into consideration the response that I had, today being very important day as far as my family is concerned, and this happens to be our wedding anniversary, everybody agreed, everybody decided that I should do something, or we should do something for the society, and hence today also I have decided to start a recording as far as very important subject is concerned, namely the Negotiable Instrument Act. Negotiable Instrument Act, as per the name, is very difficult to negotiate, but then thought that I shall try my best, as I have done in case of Criminal Procedure Code and the Indian Penal Code, to make this very interesting and also simplify the subject to such an extent, as a result of which it will not only help the students of law, but one who listens or one who has watched my videos as far as Negotiable Instrument Act is concerned may be in a position to understand, and hence the importance of this day, why again after 1 year I have started recording as far as the Negotiable Instrument Act is concerned, being our wedding anniversary. With this now, let us, I don't want to waste your valuable and precious time, so let us start with the provisions of the Negotiable Instrument Act of 1881. Now, as I had told, and this I shall be telling in the future too, in order to understand the provisions of the Negotiable Instrument Act, please do have a bare act of the negotiable instrument as you go or try to understand the provisions of the Negotiable Instrument Act. To understand Negotiable Instrument Act, we will have to start right from section 1 and go up to last section, namely section 147 of the Negotiable Instrument Act. Negotiable Instrument Act was when enacted in the year 1881, and up to 1988 we had only 137 sections as far as the Negotiable Instrument Act is concerned. But as a student of law, you will always remember one thing and understand one thing, that law is an instrument of social change. Law is an instrument of social transformation. Law is an instrument of social engineering. So as a student of law, we all agree that law should be dynamic and it cannot be static. Taking into consideration the need that was felt by the legislature from 1988 onwards, this was, we had one chapter, last chapter, right from section 138 up to section 147, which dealt with regarding dishonor of a check. Today, why we are not going to work out details regarding the same, because this is just an introductory lecture as far as the negotiable instrument is concerned. Now, if you start reading negotiable instrument, you will come to know an act to define and amend the law relating to promissory notes, bill of exchange and checks. So this is for what is the object of the act? This is the object of the act, that an act to define and amend the law relating to promissory notes, bill of exchange and checks. Does it mean that these are the only negotiable instruments? And the answer is naturally in the negative, of which you should take serious note. But then if you refer to, generally we start with section 1, but this is a time where I want to draw your attention to section 13 of the Negotiable Instrument Act, which says negotiable instrument. So Negotiable Instrument Act deals with what? Negotiable Instrument Act of 1881 deals with negotiable instrument. And what is negotiable instrument? There is no definition of negotiable instrument, but if you read section 13, so right in the beginning, the first section where I want to draw your attention to section 13 of the Negotiable Instrument Act, which says a negotiable instrument means a promissory note, bill of exchange or check payable either to order or to bearer. So what is negotiable instrument? Negotiable instrument means a promissory note, bill of exchange or check payable either to order or to bearer. So Negotiable Instrument Act deals with only, there may be n number of other negotiable instruments, but the Negotiable Instrument Act deals with only 3 types of negotiable instrument, namely the promissory note. In order to understand promissory note, what do you mean by promissory note and details, we will work out when we refer to section 4 of the Negotiable Instrument Act, which defines promissory note. To know what is bill of exchange, it is defined as far as section 5 of the Negotiable Instrument Act is concerned. In order to know check, we have to refer to section 6 of the Negotiable Instrument Act, which defines check. Is it necessary for you to remember section number or the definition as it is given in the book? No, certainly not. But then what is expected, or how it is possible for you to understand what is promissory note? As when we shall be dealing in detail as far as a promissory note is concerned, section 4 says promissory note is an instrument in writing, not being a banknote or currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. As far as section 5 is concerned, which defines bill of exchange, it says bill of exchange is an instrument in writing containing an unconditional order signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. That is as far as bill of exchange is concerned. And then when we refer to section 6 of the Negotiable Instrument Act, we understand, or it defines what do you mean by check, which says check is a bill of exchange drawn on a specified banker, not expressed to be payable otherwise than on demand. So these are the instruments, namely promissory note. To know the details as far as the promissory note is concerned, yes, we will read the section, we will analyze the section, we will carry out this section of the section and try to find out what are the ingredients to constitute valid promissory note. Same is the case as far as bill of exchange is concerned, and naturally we shall be dealing with the same as far as check is concerned, which is defined as by section 6 of the Negotiable Instrument Act. So these are the 3 negotiable instruments with which we shall be dealing as far as the Negotiable Instrument Act is concerned. But then this is also the time for us to understand as to what is the importance of it. if A draws a promissory note in favor of Mr. B, or if A draws a bill of exchange in favor of Mr. B, or A draws a check in favor of Mr. B, what is the purpose that is served? Now, being a negotiable instrument, what do you mean by negotiation of a negotiable instrument? We shall be dealing, no doubt about it. But if A draws a promissory note in favor of Mr. B, Mr. B is entitled to get the amount for which the promissory note is drawn when it becomes mature. This is not the time to understand regarding maturity, with which we shall be dealing during the course of our lectures. Yes. Or when A draws a bill of exchange in favor of Mr. B, yes, B can claim the amount with respect to the bill of exchange, namely the amount for which the bill of exchange is drawn, as soon as it becomes mature. Same is the case as far as the check is concerned. So if A draws check in favor of Mr. B, B can get the amount. Now, how he can get the amount? What is the procedure that is required to be followed, with which we shall be dealing as we are going to understand the provisions of the Negotiable Instruments Act. But this is a time for me to draw your attention that as this is a negotiable instrument, what does it mean? It is a piece of paper. Yes, it is a piece of paper. And what you write on the piece of paper decides whether it is a promissory note, whether it is a bill of exchange, or whether it is a check. And then you have it with you, you are payee of it, yes. And then payee is entitled to get the amount. So by putting a piece of paper into circulation, by merely handing over a piece of paper, namely maybe a promissory note, bill of exchange or check, you become entitled to the property, namely the amount for which it is drawn. That is one aspect. Not only that, yes, along with this being the negotiable instrument, you can transfer, be maybe promissory note, maybe bill of exchange or maybe check. He can get the amount or claim the amount for which the promissory note, bill of exchange or check is drawn. But at the same time, if he doesn't want the money, but if he wants to pay that money to somebody, instead of going to Mr. A or the person who is supposed to pay the amount, he can pass on, he can negotiate that negotiable instrument, namely Mr. B can hand it over to Mr. C, and then Mr. C, to whom the negotiable instrument is negotiated. So this is the concept where instead of transferring cash from one hand to another hand, Mr. C can get the amount for which the negotiable instrument is drawn, or Mr. C can put it into circulation to Mr. D. How long a negotiable instrument can remain into circulation? A negotiable instrument can remain into circulation till it becomes mature. After maturity also it can remain into circulation, but then the most important characteristic which I want to point out today itself at the time of this introductory lecture is that negotiable instrument is an exception to the maxim nemo dat quod non habet. This maxim, when you deal with the provisions of the Sale of Goods Act, or when you deal with the provisions of the Transfer of Property Act, you come to know that what is the meaning of the maxim? You cannot transfer better than you possess. Or your title, namely title of the transferor, title of the transferee is not better than that of the title of the transferor. In other words, if the title of the transferor is defective, title of the transferee also becomes defective. But as I have already told you, negotiable instrument is an exception to the maxim nemo dat quod non habet, even though the title of the transferor is defective. Title of the transferee becomes clear only in a case that transferee can be labeled, or he can be labeled as what is known as holder in due course, as defined by section 9 of the Negotiable Instrument Act. In other words, once the negotiable instrument reaches the hands of a holder in due course, to understand holder in due course, we will have to understand what do you mean by holder, which is defined by section 8 of the Negotiable Instrument Act. Today is the day when I shall be making you aware regarding certain basic terms to which you must be familiar, and then once you are familiar with the terms, during course of time we will understand the importance of the term and the meaning of the term by having reference to a particular section. So if a person becomes a holder in due course, and then in order to become a holder in due course, it is always the state of the mind of the transferee that is taken into consideration. If he has received the negotiable instrument honestly, and then if it is found out that he has received a negotiable instrument from a person whose title was defective, but this he had no reason to believe that he is deriving a title from the person whose title was defective, in that case naturally he becomes, there are other conditions which are required to be fulfilled, with which we shall be dealing as we will try to understand ingredients of section 9 of the Negotiable Instrument Act, which defines holder in due course. Yes, but otherwise, if he is a holder in due course, then even though, and it is because of this exception to the maxim nemo dat quod non habet, there is free circulation of the negotiable instrument not only within the territory of India. We are dealing with the Negotiable Instrument Act of 1881, which extends as usual to the whole of the India except the state of Jammu and Kashmir. But it's not only that there is a free circulation of a negotiable instrument only within the territory of India. There can be circulation of the negotiable instrument beyond the territorial limits of India, for which we will have reference to international law to a certain extent also during the course of our lectures. Yes, we will have reference to that. So this is because of the fact that this is one, I can say this is the most important characteristic of a there are many characteristics of the negotiable instrument, out of which this is, in order to have free circulation, nobody will hesitate to accept the negotiable instrument, and accepting negotiable instrument does mean you just have a piece of paper, and this piece of paper as dealt by section 13 may be a promissory note, may be a bill of exchange, or may be a check. Yes, it is so. But by getting a piece of paper, you ultimately get what? You become entitled to amount, namely the property for which the negotiable instrument is drawn. So this is the property that passes. What is the property? The amount for which the negotiable instrument is drawn. And hence, this is one characteristic of which one of the characteristics, but I per se, all characteristics are important, no doubt about it. But in order to have free circulation, this is one characteristic to which I have referred to, which we shall be repeating and dealing in detail during course of time. With this now, when you have a promissory note with you, or you have a bill of exchange with you, or you have a check with you, and then the person who is supposed to carry out payment. Now this is not the time for me to confuse you by telling, but in case of promissory note, you have two parties, maker of the promissory note and the person to whom it is made payable is the payee of the promissory note. Yes. In case of bill of exchange, we have three parties, namely drawer, drawee and payee. And in case of check also, we have three parties, namely drawer, drawee and the payee. So this is person who is supposed to get, and then if it is put into circulation, if it is negotiated, ultimately the person who wants to get the amount for which the negotiable instrument is drawn during course of time, and if it is the amount is not paid to him, naturally he shall be compelled by the circumstances to go to the court of law to establish his right. Now, as a student of law, whenever you go to the court of law in order to establish your civil right, this has got reference to what? Right from section 101 up to 114 of the Indian Evidence Act, where you will learn, as per the provisions of the Indian Evidence Act, that the burden of proof lies on that particular party who asserts a particular fact. Yes, you will have to prove. So now he will have to prove everything in a court of law, no doubt about it. But the other important characteristic to which I want to draw your attention is section 118 of the Negotiable Instrument Act, which deals with presumptions. There are many presumptions with respect to the Negotiable Instrument Act with which we shall be dealing as we start understanding negotiable instrument, and it is because of the presumption, court shall presume. What do you mean by shall presume? We will have a reference to section 4 of the Indian Evidence Act too. But then it is not for you to prove anything in a court of law. The court will take it for granted, and that is with which we shall, during course of time, we will understand. But it becomes very easy for you as we start discussing the provisions of the Negotiable Instrument Act. During the first lecture itself, I must make you aware that to understand the provisions of the Negotiable Instrument Act of 1881, you must master, because what is promissory note? It is a contract. What is bill of exchange? It is a contract. What is check? It is a contract. And hence, to know all these negotiable instruments of which base is contract, you will have to know the provisions right from section 1 up to section 75 of the general principles of the contract. So unless you know the general principles of the contract, and unless you know what is contract, contract is an agreement which is enforceable by law. So now this is the time, let me tell you that by merely reading right from section 1 up to section 147 of the Negotiable Instrument Act, if you say refer to these sections only, it may not be possible for you to have mastery or simplicity as far as the understanding of the subject is concerned. This is possible only when you learn law in totality. You have what is known as holistic approach. In order to, as I told you, as it is a contract, you simultaneously, it is necessary for you to know the general principles of the contract. Yes, during course of time there are many more enactments with which we shall be dealing. But then as we proceed further, you will understand everything subject to one condition. Whatever is told by me during course of my lecture, you will have to study that. For example, when I have drawn your attention to section 4 of the Indian Evidence Act, in order to know section 118 of the Negotiable Instrument Act, it is must. In order to understand the characteristic that it is an exception to the maxim nemo dat quod non habet, transfer of property as far as immovable property is concerned is dealt by the provisions of the Transfer of Property Act. Yes, but when the property is what is known as movable property, it is the goods, then it is dealt as far as the Sale of Goods Act is concerned, which also deals with transferring of property. The person who has sold out the property ceases to be the owner of the property, so he is known as a seller, and buyer becomes owner of the property. Yes, but then, as I mean, this is an exception. This is an exception. You must master the principle as far as transfer of property is concerned. Yes, that is, transfer may be transfer of ownership, property in the goods from one person to another person during course of time. So then only it will be possible for you to understand the importance of the Negotiable Instrument Act is concerned. This we shall continue our discussion as far as the rest of the lectures are concerned, with which we shall be dealing during course of time.